welcome to the Legal Insight podcast by HHQ, where we unpack the world of technology, law, and everything in between. Now, this is the second part of our deep dive into the Online Safety Act 2025, a law that only came into force recently on 1st January 2026, and yet has already generated a significant volume of interest, questions, and inquiries from companies, in-house legal teams, lawyers, and directors across the region. In our previous episode, Johnson and Khai walked us through the foundation of the Online Safety Act, and what the law is about, and how it differs from other tech legislation such as the Cybersecurity Act and the PDPA, how it fits into the broader tech regulatory ecosystem, who it applies to, and its extraterritorial reach. And perhaps most critically, what we covered in the last episode was what the law considers as harmful content and whether that definition is sufficiently broad enough to meet the Act's objectives. Now, if you've not listened to episode 32, I strongly encourage you to go back there before you start this podcast. So today in episode 33, we're shifting gears from understanding the law to understanding what the law is to understanding how it actually works in practice. That will be focusing on the execution, the compliance, mechanics, user-facing obligations, reporting mechanisms, and child protection measures. I'm very pleased to welcome back Ong Johnson and Lo Khai, the co-head and head of Technology Practice Group. Welcome to the show, guys.
Good to see you, Zach. Pleasure to be here.
Let's get straight into it. Now, Johnson, at its core, the intention of the Online Safety Act 2025 is to regulate, mitigate, and ultimately minimize harmful content in the digital space. Now, legislation only works if it translates into real executable obligations. I'm sure you would agree with that. One such obligation is the requirement for licensed application service providers, which Khai covered in the last episode, and licensed content application service providers to publish guidelines to users. Could you explain what this guideline publication obligation actually entails under the Act, and why is it so important?
Yeah, Zach, always happy to see you. So as mentioned in the previous episodes, just to lay out the context of what the Online Safety Act is all about. So the Online Safety Act is really here to govern, to regulate, to mitigate, and most importantly is to reduce harmful content that is made available online or on the digital space. So I'm sure that everyone could agree that ultimately that is the objective that we want. And then we are rather tired of hearing government or regulators saying that, oh, I just want company to be doing that without imposing actual obligations. So with the Online Safety Act being implemented, being enforced, so the law imposed very clear obligations upon ASP or CSP or even NSP to a very small extent on what they are supposed to do on their actual obligations to reduce, to mitigate, and to remove harmful content made available online. And one particular obligation that I personally think that is most important and also most useful is they actually force them that you would need to make it very clear. You have to pen it down in a form of guidelines or guidance to the users saying that what are the measures that your company is going or have already implemented to reduce, to mitigate, or to remove harmful content made available online. So coming from a compliance background, a lot of times company, they have internal policy. One thing about internal policy is internal. They are able to hide behind the compliance wall, saying that we have our internal compliance, but I'm not going to tell you because these are internal information. Now the lawmaker, the regulator, they make it very clear by saying that I need you to be fully transparent and then make into something like a guideline or even like a guidance to the users. So the users and regulators, they're able to really see what kind of measurements have you implemented or are you going to implement to ensure online safety is being safeguarded. So with that, we are seeing transparency and most importantly, accountability. So it means that for MCMC, for regulators, or even for users like us, it's so much easier for us to audit and to hold them accountable.
Thanks, Johnson. Now, Khai, your team frequently assists tech companies in drafting terms of use, terms of service, all the time, right? Community guidelines, user manuals, all these compliance documents. Now, for companies listening in right now, is this guideline obligation under the Online Safety Act simply another version of one of those documents, one of those notices, one of those terms, right? Or is it something a bit different? How should companies actually reconcile what they already have with what the Act now requires?
Yeah, thanks, Zach. That's a very practical concern, and it's also a question that we've been asked quite a number of times since the ONSA comes into effect, right? While there is some level of overlap between the guidelines as required under the Online Safety Act and also the terms of use or terms of service that software companies would publish on their website or even on their software itself, the interface of their software itself. So typically, maybe let me unpack a little bit first. What is typically a terms of use? What can you typically find in a terms of use or terms of service? Terms of use or terms of service is objective at the end of the day is to create a contractual obligations between the software vendor and also the user. So because it's a contract, right? While it will set out to some extent how do you use the services of the software service provider, that whether you need to create an account, you need to subscribe on a monthly or annual basis. But at the same time, it will also have the typical clauses to protect the interests of the service providers. Like let's say commercial provisions, how much do you have to pay, for example, the terms of usage, whether there is a limit in terms of how much you can use, and if you use extra above and beyond, whether that translates to overage charges, and the usual service levels agreement, IP ownership clauses, IP indemnity, limitation of liability even. So all these things would be very commonly found in terms of use or terms of service. But the guideline that the ONSA is imposing on the service providers, the three classes of service providers that we mentioned just now, it's actually for transparency purpose, as Johnson has mentioned. It's to make sure that the platforms communicate clearly to the users the type of measures, safety measures, online safety measures that these platforms have put in place, and how the users can actually make use of all these safety measures. So the requirement of the law is actually that you need to have a guideline that sets out the transparency part on online safety measures, and at the same time, the guideline needs to also encompass the terms of use or the terms of service. So, like it or not, ASPs, CASPs, and to some extent NSPs, you will have to look into your terms of use or terms of service to essentially tweak it for compliance with the Online Safety Act, to include the transparency requirement as well, setting out all the online safety measures that you have put in place or the Act is requiring you to put in place. But at the same time, actually before the platforms can even do that, the MCMC is supposed to be issuing a code first. So there needs to be a code to set out the measures, online safety measures that these platforms need to implement. Then only the platforms will be able to amend their TOU and their TOS.
And the code is not.
No, currently it's not out yet. Yeah.
So now let's go a bit deeper. Beyond the guidelines, the Act also requires licensed application service providers and licensed content application service providers to make available sufficient tools and settings to enable users to manage their online safety. I think that's a very practical thing to implement. Now, but it sounds quite broad at the same time. Could you elaborate on what the Act actually is expecting platforms to provide in this regard?
Yeah. High level basis, the Act is actually trying to strike a balance between platform control and also users' discretion. So essentially putting the tools in the hands of the users, allowing them to have some ways to protect themselves, right? So at the minimum, the law would require tools that allows users to prevent or limit others from identifying, locating, or communicating with them. So if I don't like you or Zach, I don't like Johnson, I should be able to block the two of you on, say, Instagram from reaching out to me or from viewing my content online, right?
Sure.
So that's essentially the gist of it. Immediately you think of having some features to block other users from viewing you or from reaching out to you. And at the same time, things like making your account private so that people need to request to follow you or to request for permission to view your content. If you look at Facebook, if you look at X, if you look at Instagram, they have even more advanced features, like let's say turning off account suggestions so that you won't be suggested with simply anyone's account, and at the same time your account won't be suggested to other people that you may not necessarily know as well. And so Instagram particularly has a limit interactions functions with certain toggles and certain features that you can actually play with. So the key point is that these tools, they must be effective and accessible and easy to use, intuitively easy for users to actually just go through the list and know that, okay, these are all the things that I can do, I can play with my account to make sure that either I make myself more accessible or I make myself less accessible. So at the end of the day, this shifts from being purely reactive to something that is proactive and user-centric.
Yeah.
That's very good. Now, Johnson, building on what Khai has explained, could you share perhaps 2 to 3 practical examples of tools that you and the team have commonly advised clients to implement in order to meet these obligations?
Yeah, of course. So just now, building on what mentioned by Khai earlier, ultimately the entire Online Safety Act, they have suggested that you need to have tools. So one of the key points mentioned by Khai is that they wanted to actually grant more control towards the users. So the user, they were able to actually control what kind of content they want to be seeing, and most importantly, who will be able to access to their profile. Immediately, there are like 2 very important tools that's potentially already being implemented by some of the social media companies. The first one is we call it the content algorithm control. It means that as a user, I will be able to make it very clear what kind of algorithm, what kind of content that I want to be seeing. Of course, as mentioned by Khai, I'm able to block certain kind of content. For example, I'm able to block out certain kind of keywords. With that, I'm able to remove some content. But a more powerful tool and something that I trust that most of the users they want is more than just blocking. What they want is something that they are able to actually amplify or to specify the kind of content they want to only appear on their platform. For example, like for certain kids, they love trends. So in that particular case, the parents can set by saying that the content that should only appear on my child's social media platform is only everything in relation to trend, but only trends. You will not be seeing and also allowing my kids to see anything else except trends. With that, you are giving the power, the control back to the users. Another thing that is extremely important is a lot of time harmful content. Of course, they can force you to be seeing harmful content through the feed. Another way of spreading harmful content is people can just DM some stupid thing into your message. And then a lot of time, especially a lot of kids, they already have exposure to social media. The last thing you want is some creepy guys to be DMing into your kids' social media account, in which you may not even be aware of. With that, what we want to do is you want to be able to actually have a stronger privacy setting, including who will be able to message to your profile, who can view your profile, and most importantly, is like the location of your profile. Because there are certain times where when you post a photo, somewhat the social media platform, they will have a suggestion, say that I'm in KLCC, I'm heavily and I'm actually in Paris. With that, to be honest, it's going to be very, very dangerous. And to be honest, these tools are not particularly difficult to be implemented. It boils down to whether those companies, AST, CST, do they actually have the desire, are they determined enough to impose these kind of tools and to return certain kind of autonomy back to the users?
Wonderful. More power to the people. Let's shift gears slightly now. One of the most talked about aspects of the Online Safety Act 2025 is its ability for users to report harmful content. Now, from a user's perspective, what is a correct way to report harmful content under this law, and who are they actually reporting to? I think, I've done it myself before. Just like, okay, this content is harmful, it's either suggestive or sexual, or this is a bot, or this something. So, I'm not sure where it goes to in the end, and there's nothing usually. Either it goes months without any sound and it just says, the case has been closed. Actually, where does it go to and how should we use it?
Yeah, so the Online Safety Act is particularly amazing. And then another thing I really like about this Online Safety Act is it provides this kind of flexibility. We call it a dual reporting mechanism. So it means that as a user, in the past, without the Online Safety Act, whenever there's any harmful content, typically what we do is, as you mentioned, you only just lodge a complaint to the social media platform. But under the Online Safety Act, they actually have a dual reporting mechanism, which allows you, number one, you are able to make a report directly to the social media platform provider. On top of that, you can also make a direct report to MCMC. In other words, in the event that you think that this social media platform, ASC or CSP, they are not responsive, I don't want to deal with them anymore, I want to directly make a report to MCMC, you are able to do so. In the previous episode, we mentioned about the Grok beginning incident of what's happening on Twitter and X. With that, many users, including some of our clients, what happened is they make a report to X. There is a very standard procedure, the protocol. And yet at the same time, because the Online Safety Act was being implemented, come to force on 1st Jan. So many use the opportunity, they lodge a direct complaint, direct report to MCMC as well. With that, Fahmi, which is our communication minister, immediately reached out to the local representative of X, and then they actually reached a settlement. They managed to resolve the matter within a very short period of time. I think this Online Safety Act is extremely powerful and then extremely flexible because it allows a dual reporting mechanism.
That's really useful.
Yep.
Yep.
Yeah. So now, Khai, could you walk us through the reporting process at a high level from the moment a user encounters a harmful content to the potential involvement of MCMC in this example?
Yep.
Yeah, so this is more for users' expectation lah. So the users, what would happen the moment you lodge a complaint, right? Essentially, after you have lodged a complaint to a platform, the platform will have a set obligation to acknowledge receipt and to look into it to determine whether the content that is reported is harmful. So under the law, there are two categories of harmful content: ordinary harmful content and also those that are priority. So depending on the type of harmful content, the level of urgency, and also the time required to respond on the platform's part will also differ. If the content is indeed assessed to be harmful, then the platform will have to immediately remove access to the content temporarily while you conduct further investigation to confirm that the content is indeed really harmful. So if the second assessment still confirms that the content is harmful, then you permanently disable it. So from the user's perspective, or from the content creator's perspective, those that actually uploaded the content that is being the subject matter of the complaint or the report, right? Whoever that is aggrieved by the decision of the platforms will be able to make requests for an inquiry. Essentially, you are trying to seek an appeal, get the platforms to reconsider or perhaps to relook into the matter and see whether there is any mistake in coming to the decision or not. So that's on the platform side, right? Now we talk about how MCMC can intervene. Johnson mentioned just now, there is actually a dual reporting mechanism. So what's really, really good here is that users don't have to. It's not that users must submit a report to platform first, and maybe after a certain set time, if the matter is still not resolved, then only you can go to MCMC. But rather, the Act makes it very, very clear. You can actually go two ways at the same time, two routes of complaint at the same time. So this ensures that the right level of attention will always be achieved either on the platform side or on the MCMC side, should there be a need for MCMC to directly intervene. So of course, that's the dual reporting mechanism. And at the same time, if MCMC finds that the decision taken by the platform is not in line with MCMC's view or MCMC's assessment, they can also intervene at that point in time and direct the platform to either resume access or to permanently disable access to a particular content. So one thing that we would always like to highlight about this whole reporting regime is it's very similar to the safe harbor provisions under the Copyrights Act. Copyrights also have very similar provisions on platforms for users, let's say social media companies. Users can actually go to them and say that, hey, whatever content that I found on your platform is actually copyright infringing, whether it's infringing upon my copyright or copyright of someone else. I can actually make that report. And Copyrights Act also sets out a very similar process, essentially, to the point where these two acts, they both sets out the number of the length of duration, essentially, that platform needs to take action. Let's say within 4 hours, within 1 hour, within a few days, right? So even if platforms have the necessary procedures and processes in place, but if they fail to even adhere to the timeline requirement, that in and of itself will also translate into a liability, a non-compliance with the legislation on their part.
That's good. That actually solves the issue of users feeling powerless. Like oftentimes we just feel powerless. Like you submit a report, it comes back, it's like I've investigated myself and I found nothing wrong. So there's just a feeling of like, there's nothing that we can do. But now there is a second solution, right?
Yes.
Now we know that not all content or harmful content are created equal, and
Yeah.
content involving children is particularly a sensitive
Yes.
issue.
Yes.
Does the Online Safety Act impose any specific or heightened obligations when it comes to child users?
Yes, there are two parts to address here. I mentioned that when it comes to harmful content, there are two levels of harmful content: priority and also ordinary harmful content, right?
Yeah.
Child sexual abuse material falls under the category of priority harmful content. So essentially, if a platform receives a complaint or a report about a content which they then subsequently assess to be CSAM, then the level of urgency immediately heightens
Yeah.
up, immediately spikes up. They need to take action on a much quicker scale according to the Act. And that aside, right, platforms, they also have a duty to implement measures to ensure safe usage of their services by child users, essentially. I won't go through in details what are the measures the measures to be put in place. Essentially, it is still subject to a code to be issued by the MCMC. So MCMC is supposed to be issuing a code to detail out all these child safety measures, essentially. But we know at this point in time, based on the wordings of the Act, that at the minimum, the measures will include twofold. Those that deals with child users' interactions with other users. So essentially things like preventing adults or preventing other people from locating the child users, or to reach out to them, DM them, sending them stuff. And the second part would be the child users' interactions with the platforms itself. So the platforms need to have measures to allow child users to tweak the content that is being suggested to them.
Yeah.
From an algorithmically standpoint. And also, this is a little bit more interesting. The platforms need to be designed in such a way to reduce features or functions that would increase the length of time that the child users would actually stay on the platform.
Yeah.
So it's like trying to get social media to prevent us or to prevent kids from doom scrolling, from spending too much time on the platforms.
Yeah.
Exactly how that will be done, I don't know. I'm very, very curious to find out as well, and we are all waiting for the code to be published.
Yeah, I need to prevent myself from doom scrolling too.
Yeah, I need that as well.
Now, Johnson, as we close off this episode and on Online Safety Act 2025, of course, there's many more things to be discussed, right? There's a question many stakeholders are asking right now. Do you see the Online Safety Act as a sword or a shield, or shield for society? And ultimately, is it sufficient to protect Malaysia's digital space?
Yeah, very, very good question. Because most of the law, especially in Malaysia, is designed either to operate as a sword or as a shield. But the Online Safety Act, I would say that it's a rather special creature of its very own. The reason because it is actually both a sword and also a shield.
Yep.
So first of all, the MCMC, the regulator, the law itself make it very clear by imposing very clear obligations on the platform providers, whether you are ASP, NSP or CASP. Most importantly, number one, you will need to carry out certain kind of obligations in relation to the law. And on top of that, just like we mentioned, that it is also returning certain kind of power or control back to the users. One of the most powerful tools that we are seeing now is actually the dual reporting mechanism, in which if you are not happy with the service provider, you can directly make a report to MCMC. And we have seen how effective and how powerful it is, especially with the Grok Bikini Saga. So with that, we really think that this Online Safety Act is an extremely good sword and also a shield that is much needed in Malaysia. For the second question, do we think that actually the Online Safety Act is sufficient to protect Malaysia digital space? Answer is potentially so, but is it perfect? Far from it. Just like IP, it takes them many, many years for them to actually mature, to have different kind of IP laws, trademark, patent, industrial design. So for Malaysia, we have our PDP law, we have Cybersecurity Act, and this year we do have a new law, which is the Online Safety Act. Is it sufficient? Does it mean that overnight there won't be any more harmful content in Malaysia? Answer is no. The law is still developing, but we are certainly heading towards the right direction.
Wonderful. Thank you, Johnson and Khai, for this incredibly insightful discussion over the past 2 episodes. And I think our listeners now have a much clearer picture on how the Online Safety Act actually works in practice, from user guidelines, safety tools, and now reporting mechanisms and child protection
Yep.
measures. So for companies, in-house teams, and legal practitioners, the message is very clear. This is not a law to be observed from a distance, or it's not a box-ticking exercise. It requires active engagement and very thoughtful implementation as well. So thank you for tuning in to the Legal Insight podcast by HHQ. Until next time, we'll see you soon.